This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Well, welcome. Hi, Gary, to the Altar of Bard. It's been 2 weeks. How are you for our Sunday morning?
I'm very well. Happy Sunday, Mark. Good to see you.
Good to see you, too. Once again, I'm not dressed up. I had time. I don't know what's the matter with me. I apologize. But next, look at you with your Engine Vision Media shirt. I love it.
There you go. That wasn't an accident.
Okay. Good for you. I think it's been 2 weeks, and we started, I believe, 2 weeks ago with a Bill Maher intro, and I think we're going to do it again because this story is it's right up our alley.
Yeah, absolutely. Let's check it out. I've got it right here, and we'll check this clip out from Real Time with Bill Maher that aired, I believe, Friday.
It wasn't here 10 years ago. Now we see it.
And it's also disturbing that it's the kids. I mean,
the future leaders of our country.
Again, but they're kids. Let's think about the
they're not kids. They're not kids.
Let's think about the leftist
These are law students. These are law students. The head of NYU's Law Student Bar Association signed one of these blood-curdlingly anti-Semitic letters. Unfortunately, the law firm, where she had been a summer associate and she had a job opportunity, they rescinded that job opportunity. One more thing. You know, we have certain taboos in our society. There are things that you cannot say and be accepted into socially respectable company. Certain things about race. You can't make bigoted or sexist comments about women. For too long, people have been allowed to get away with anti-Semitic remarks and still have their careers intact. And I think there needs to be a higher social cost, not a legal cost. There needs to be a higher social cost for the kinds of things that we've been seeing over the past week.
One thing I want to point out there is that he gendered the person from the NYU as she, but in all the articles I've read, they identify as non-binary. So, I believe they use the they, them pronouns. So that was one thing that was just a little bit unusual in that one.
And because there was so much cross chatter there in the beginning, they were trying to get to the point. The remedy here is that who was the gentleman who was arguing for a social cost, not a legal cost?
Let me pull up his name here real fast. Just take me a second. Because
it's an interesting, there's been this, there's been the offer rescinded, there's been the talk about expulsion. If you have a discussion on this, and if you're somebody who believes in free speech, it's an interesting subject that all of a sudden there are certain lines that people are asking for. The idea of making a distinction between a legal cost and a social cost, what does that really mean?
Yeah, that's a very good question. There seems to be a lot of dancing around the topics these days.
Jewelry is having a big moment right now, and with hundreds of products popping up in your feed every day, it can be hard to find a brand you trust. Alex and Ani has been creating meaningful jewelry for over 20 years, designing pieces that connect you with all of life's important moments. With an emphasis on value, there's truly something for everyone. You might be most familiar with their signature charm bangle. This bracelet literally created the category of meaningful jewelry and had you stacking charms from your wrist to your elbow. This piece is an icon for a reason. Completely size inclusive, each bracelet is adorned with a symbol designed to tell your story and express your unique style. Beyond the bangle, you'll find stylish, affordable jewelry for every occasion, from classic pieces to bold statement looks. Don't know where to start? Alex and Ani makes it easy to unpack the trends you're after and sprinkle in your personality too. Each piece comes with a personalized message and meaning, truly making it the perfect gift. You can take comfort in knowing that you're shopping with a socially conscious brand as well. To date, Alex and Ani has donated over $60 million to nonprofits worldwide, connecting fashion and philanthropy in an easy, fun, affordable way. Visit alexandani.com right now to discover the confidence that comes with a perfectly accessorized piece of jewelry. Right now, Alex and Ani is offering our audience 20% off with code MIDAS at checkout. Again, head to alexandani.com. That's alexandani.com and use code MIDAS at checkout for 20% off your order.
Well, somebody will tweet at us as to who that is. It's an interesting issue. There are so many cross currents about this going on. The various kind of constituencies are taking their usual tribal positions on this. I noticed earlier this week, Kimmy K tweeted about and linking this to the Azerbaijan invasion and basically ethnic cleansing of Artsakh and moving 120,000 people, besides also doing beheadings and things of that kind of the savagery. And there is in the Armenian community quite a bit of angst over the fact that the world has come out immediately to condemn all of these actions by Hamas, who, by the way, there's also, whether it's true or not, there's Hamas support for Azerbaijan. And interestingly, Israel was supplying the Azerbaijanis with military equipment for that. I mean, the oil and geopolitical dimensions here are just it's for another show at another time. One of the things that I'm interested in, though, is this idea that I just mentioned, the difference between a social cost and a legal cost. I'm not so sure that you can make that nice, clean distinction between the two, because what you're basically talking about is trying to wreak some kind of, when you say social cost, that's an economic cost. You're not going to get a job. You're going to have your offer rescinded. You're going to be, you're going to have some kind of a economic consequence. I don't think we're talking about pure shame.
Yeah, no, it's certainly that's a high wire act that gentleman's trying to walk there.
Yeah, with people cheering him on, which is great. That's that's where we're at. The next story, which I thought was interesting, is the Georgia story with Sidney Powell. I believe there was a motion in limine filed this week, and the motion in limine was basically to make this a pure legal question of what's happening in Georgia, that she was giving legal advice. You have it there handy, Gary? It was not a very long motion itself.
I do. You want to watch the clip first that we
sure.
pulled?
While you're looking at it, let's do that.
Okay.
For two of the defendants in the Fulton County election interference case want their case dismissed. Kenneth Chesbrough and Sidney Powell are charged alongside former President Trump and others for interfering in the 2020 Georgia election. Chesbrough and Powell are scheduled to go to trial later this month. Fox 5's Christine Spiro joins us from the live desk with the latest developments in today's hearing. Christine?
Yeah, Courtney, the hearing lasted 2.5 hours and covered multiple motions. We're going to focus on one of them, which was, as you mentioned, the motion to dismiss the case against Kenneth Chesbrough and Sidney Powell. In fact, Chesbrough was at the hearing in person, sat with his defense attorneys, listening attentively throughout the hearing today. Defense attorney said the case should be dismissed based on the supremacy clause. That specifies certain federal acts take priority over any state acts. In this case, the defense says Congress is the one who ultimately determines who wins each state's electoral college votes. Therefore, the state of Georgia cannot prosecute or regulate those actions. So Chesbrough's attorney said today the memo he drafted, or he's accused of drafting, that spelled out how to create this second set of electors in no way concerns Georgia or its rules, processes, or procedures. So they say the charges against Chesbrough are invalid.
So the issue.
It's an interesting argument, because I think it's got some legs. What they showed on the screen, for those of you who aren't watching, they called it a demur to the indictment. A demur to the indictment basically means that you take a look at the four corners of the indictment, and if it does not, as a matter of law, meet what the charges are, that the factual allegations, you're challenging the way that it's been drafted, then you can make the argument that they just made. You could do it that way. You could do it as a motion in limine. I don't know what the particular Georgia procedural vehicle is, but a demur is one way to do it. Other jurisdictions, you do a motion to dismiss. But what their argument is that that giving the advice, drafting a memo, is a specifically towards a action that impacts a federal election, that Georgia should not have a involvement in that. The state of Georgia is preempted because that's peculiarly federal. I'm not so sure that argument is going to win the day, because clearly under the Constitution, the individual states have electors and have an interest in sending the electors. The whole idea of January 6th was that the electors and the voting would be presided over. I do have, however, and I'm not sure, I confess to ignorance as to whether they made this argument. I think there's an argument that the giving of the advice to somebody is purely squarely within the attorney-client privilege. Now, I know what the counter argument is, because we had that in the Central District in front of Judge Carter, was there a crime fraud exception that overturning the election would have been a crime? I'm not so sure that flies either, because if in fact you're giving advice that in an attorney-client setting, a client has got a right to say, can I do this? Can I do that? What's stopping me from doing that? Your job as a lawyer is to say, well, you can do X, Y, Z, but stay away from ABC. And if you're starting to criminalize any kind of advice that you give in that context, that is not just a slippery slope. That's an absolute body blow to the idea of an attorney giving counsel and guidance to a client. So it'd be interesting to see, and maybe for next week, Gary, we'll kind of comb through the motions that have been made in Georgia, especially because we're on the eve of trial here. You know, that package that they had just talked about said trial this month. I believe trial scheduled for October 23rd. So you're in the home stretch here where you're doing all of the pretrial motions in limine, all of the things that are kind of a ramp up to a jury selection. And all of these issues are going to have to come to the fore sooner rather than later. Although you may find that the judge does one of these things where he says, you know what, I want to hear more facts first. I want to hear the prosecution case first. I'm going to reserve some of these rulings until there's such time as I've heard what the prosecution's actual case is, as opposed to the way you're proffering it to me.
Yeah, absolutely. I cut that clip off a little early. Would you like to see the end of it?
Sure.
Okay, let's check it out here.
Execute or regulate those actions. So Chesebro's attorney said today the memo he drafted, or he's accused of drafting, that spelled out how to create this second set of electors in no way concerns Georgia or its rules, processes, or procedures. So they say the charges against Chesebro are invalid.
So the issue becomes, if you are accused of being a second slate of electors, which is then being a false government official, and if you sign the vote, that's false. If you submit the vote, that's false. It makes compliance with state and federal law impossible, and that's where conflict comes in.
Now, Fulton County Superior Court Judge Scott McAfee did not make any decision on any of the motions today. In fact, the parties are going to be back in court tomorrow at 1:30. So we will be watching to see if any decision is made on the future of the case for Chesebro and Powell. Tom?
All right, Christine, thanks.
And we will be watching as well. Sorry for pulling up on that clip a little short there. I heard the transition music that news program used, and I thought that was the end of the clip. So my mistake.
We'll give you absolution for that. It's a fascinating case. I think we may start covering it a lot more because I think it's of great public interest, not just to lay people for the issues surrounding January 6th, but I think it's a fascinating issue for lawyers as well, because if you set aside whatever tribe you belong to, and just look at what is actually going on here. There are far-reaching issues when you start criminalizing the advice that a lawyer gives to a client in a situation where a client has the absolute right to ask the questions. I mean, people can say whatever they want, but you can ask your lawyer the questions. That's why you have a lawyer, and that's why you're supposed to get counseled by the lawyer. And I don't know that we want to say that basically look back and nunc pro tunc, if you will, or ex post facto change the rules depending on who wins.
Yeah, absolutely. I don't think that anyone on any side of any aisle would want to criminalize that kind of an interaction between a client and a lawyer. That's certainly a slippery slope.
It's very similar to the discussions that we've had about the laws in California that have been enacted, talking about what a patient and a doctor can converse around in terms of COVID. And it just seems that we're in a very unusual time where all of a sudden we've invaded the professional patient or the lawyer client privileges, and we want to start regulating what it is can and can't be said in the context of something that is traditionally given the confidential blanket or cloak by the law.
I believe that's Drew calling me right now to scream obscenities.
I love it. So we'll reconvene this week, and there's a whole host of other things we can talk about, but I appreciate it, Gary.
Me too, Mark. Thank you so much for making some time for us on a Sunday morning. We look forward to seeing you again soon.
Thank you.
Bye-bye.
Thanks for listening to Reasonable Doubt. Subscribe on YouTube at youtube.com/Reasonable Doubt Podcast.